Hello, everyone. Welcome to our webinar, What Contractors Need to Know About Federal Vaccine Mandates and the New Safer Federal Workforce Guidance. I am Joe McManus. I'm a shareholder with Carlton Fields Law Firm and also president of Centinel Consulting, which is Carlton Fields' construction consulting arm. I'm very pleased today to have with me my partner, Ray Vann. Ray Vann is also here in Washington with me. She's a shareholder with Carlton Fields, and she's vice president of Core Triangle Consulting. Core Triangle is Carlton Fields' it's their affiliated HR and organizational risk management consulting. And since Ray is a expert in labor and employment, she's the apt person to address you all today, and we're happy to have her here. This program is being recorded for educational and training purposes, and it includes questions and poll responses provided to you during the live event. After the recording and after our webinar today, it'll be posted on Carlton Fields' webpage, also Centinel Consulting and Core Triangle websites for your future use. During the course of today's webinar, if you have questions, then post them in the Q&A box. And what happens is we have arranged time at the end of this webinar to field questions and answers as best we can. And but put them in the Q&A. We'll check them from time to time as we go along too, and if there's something that's particularly timely to address, we'll address it during the course of today's presentation. Don't use the chat since this is recording. Please don't use the chat feature. Just put all questions in the Q&A box. So with that, I give you Ray Vann on the new workforce task guidance that's just been issued by the task force. Ray?
Thank you so much, Joe. Glad to be here today. This slide just outlines at a very high level what we hope to accomplish today. Obviously, first and foremost, we will be reviewing the, as Joe mentioned, the new Safer Federal Workforce Task Force guidance that was just issued that outlines the parameters within which these requirements are going to operate. We will spend a bit of time talking about what we can expect to see coming out of OSHA as a result of another mandate that's been imposed by the Biden administration with respect to a new COVID ETS, Emergency Temporary Standard. We'll probably most importantly to our audience spend some time previewing or talking about and providing tips and strategies with respect to how to manage these new requirements as they come online. And then finally, as Joe mentioned, we'll spend some time at the end of the program and throughout, to the extent that is possible, taking questions and engaging in discussion with the audience. Next slide. Okay, so combating COVID-19 has been, as many of you I'm sure know, a key priority of the Biden administration since day one. Literally, since his first day in office, President Biden has issued executive orders and initiated a wide range of actions to accelerate and expand the federal response to the pandemic. These efforts have come together and expanded under what the administration has called its Path Out of the Pandemic Action Plan. So this Path Out Action Plan contains 6 interrelated parts, as are listed here on this slide, including getting all vaccinated who are able. So certainly that is a focal point of this Path Out Action Plan. That first prong is the one on which a good part of the mandates that we'll be discussing today are based. But again, all 6 of these are interrelated. So in addition to getting the unvaccinated vaccinated, the other parts are further protecting the vaccinated, keeping schools safely open, increasing testing and requiring masking, protecting our economic recovery, of course, and improving care for those with COVID-19. Next slide. Okay, so the White House has been very transparent as to what it hopes the end game will be in all of this. These efforts clearly are aimed at simply getting as many people vaccinated as possible. The administration strongly believes that doing so will significantly reduce, of course, the health impacts of COVID-19 and in turn lead to faster and a more sustained economic recovery. The general approach that we've seen over the last several months has been, among other things, to make obviously more vaccines available to more people, including all those age 12 and older, to encourage and support the establishment of community vaccination locations, and to encourage the private sector to promote the benefits of getting vaccinated, if not imposing outright vaccination mandates already. And then came the Delta variant. So Joe, you'll recall, I'm sure, that in our recent podcast, we discussed the impact that the Delta variant had specifically on the Biden administration's approach to the pandemic. So
we did indeed. Last month, President Biden issued his executive order mandating COVID vaccines for federal employees and protocols for federal contractors. And of course, now the Safer Federal Workforce Task Force has released its guidance defining the parameters of the vaccine mandate and the other safety protocols for federal contractors and subs. So this is particularly important for me and my contracting clients, okay, because we're about to launch into requirements that are being put on federal contractors and others that's not necessarily in privity with the government, but how these guidance are going to affect them. And by the way, those the podcast that we did 2 weeks ago is available also on the Core Triangle, the Centinel Consulting, and the Carlton Fields websites. And I think they're especially valuable for contractors, both federal and otherwise, because Ray went through the 4 main statutes, regulations, okay, and executive orders, which are dealing with labor and employment generally, and how they affect contractors of various sizes, both federal and non-federal. So with that, I guess we'll take a look at the next slide on the Biden administration action plan here and its path out of the pandemic.
Yes. So what happened as a result of the devastating impact that the Delta variant had, and in some cases and places continues to have, was that the administration moved from less of a carrot approach to more of a stick approach to combating COVID-19. So first, back in July, on July 29th of this year, the White House issued a fact sheet announcing several new safety protocols that would be applicable to federal workers and on-site employees of federal government contractors. So the fact sheet provided that federal government employees, as well as on-site contractors, would be asked to attest to their vaccination status, and anyone failing or refusing to do so would be required to do a number of additional things. First, wear a mask at work, regardless of where they were located, whether in an area of high transmission or low transmission. They'd have to maintain physical distancing from other workers and visitors, of course. They importantly have to comply with a weekly or twice weekly COVID screening test requirement. And then finally, they would be subject to whatever restrictions on business travel that their employer or government agency put into place. So oddly, the fact sheet was not accompanied by a formal order or mandate. though we all certainly expected and understood that one would soon come down and be issued. And that happened on September 9th, as you mentioned, Joe, when President Biden formally rolled out the path out of the pandemic action plan. There was one announcement that garnered a ton of press and controversy, and that pertained to President Biden's directive that OSHA write an emergency temporary standard requiring all employers with 100 or more employees mandate vaccinations or require weekly testing. But more on that later. Next slide. Okay, so in addition to the OSHA ETS announcement, President Biden also signed Executive Orders 14042 and 14043, mandating that certain federal contractor employees and federal workers, respectively, get vaccinated. We will today again focus on Executive Order 14042, which deals with federal contractor vaccination requirements. Worth mentioning, Joe, here as well, is that President Biden's announcement also included a directive to the Centers for Medicare and Medicaid Services, requiring that agency mandate vaccinations for employees working at healthcare facilities that receive Medicare or Medicaid reimbursement. I mention that only because that's another development for which we're waiting additional guidance. So we're expecting CMS to publish an interim final rule outlining the requirements applicable to those facilities, also sometime in the next few weeks. Next slide.
Yeah, and let's dive down here if we can on this 042, and which is dealing with the safety protocols for federal contractors.
Yeah, so the executive order, essentially, both executive orders, 14042 and 14043, essentially replaced that July 29th White House fact sheet that I mentioned, which, by the way, did not impose a vaccination mandate outright, but rather required attestation of vaccination status, or alternatively, submission to weekly or twice weekly COVID testing. Here again, the Delta variant played, I think, a significant role in this change in tone and approach, as did the disappointing, I think, overall rate of vaccinations given the widespread availability by the spring and the summer of vaccines. Next slide. So EO 14042 seeks to ensure, again, that adequate COVID safety protocols are in place to protect both federal workers and government contract employees, protect them against, obviously, contracting COVID-19, or also, importantly, spreading it to others within specifically the federal workforce. So it applies to contractor and subcontractor workplace locations, as well as individuals working on or in connection with a federal government contract or contract-like instrument.
Well, you know, if I can interrupt for a second, as a government contract lawyer, I'm intrigued when they use words like a contract-like instrument, all right? Because I'm not aware of that being a particular federal acquisition regulation term of art. And so maybe I take it, do we have any enlightenment on that particular requirement, the definition here of what is a contract-like instrument?
We sure do, and the guidance actually defines a number of these key terms, and we're going to get to those in just a minute. But you're right, these terms sort of send tingles up and down one's spine to the extent that they are fairly undefined, at least to this point. Again, as I said, the guidance provides some definitions that I'm afraid, Joe, won't probably make you feel any better, but they're definitions nevertheless. So under a phase-in, before we get to the definitions, just to round out this slide, under a phase-in timetable beginning on October 15th, covered contractors and subcontractors will be subject to this new condition for contracting with the federal government, which has now been spelled out and will be spelled out in a new contract clause provision. More on breaking news development in that space a little later as well. One thing that I want to mention as well before we move on to the next slide is that, and it's important to recognize that the executive order sets a floor, not a ceiling, meaning that it is not intended, and by its terms, does not prevent states or localities from imposing more stringent requirements. We've certainly seen a number of states and localities impose strict requirements with respect to masking and physical distancing and even vaccinations and things like that. So further actually to the point that I just raised about this not creating a ceiling, there obviously are some states and localities that have either established more stringent requirements, but then on the other hand, have also placed restrictions on things like inquiring about vaccination status and or imposing mask mandates. So in terms of how the executive order operates in relation to those rules, it does explicitly preempt, or I should say really the guidance interprets the executive order as preempting clearly conflicting state and local rules, such as those that would prohibit forced vaccinations or the imposition of mask mandates. Now, to which contracts does the executive order apply? It applies very broadly, as described here on this slide, to a wide range of formal contracts and other legal relationships between or involving a business and the federal government as parties to the arrangement. Next slide.
I'm also intrigued by the procurement contract for services. I mean, is that suppliers of first tier, you know, where a government's got a purchase order agreement or with a supplier? Does it go down to multiple tiers? Is it the supplier to the general contractor who's working on a particular project, or does it apply to fighter jets? I mean, those are considered, products, services, etc. So where does it begin and end when it's on the service side?
Yeah, so the broad scope of the coverage will become much clearer when we review some of the definitions that are outlined in the guidance, but it applies extremely broadly. It applies not only to prime contractors, but there are flow down requirements to first, second, third tier subcontractors as well. The executive order actually did specify and outline who or which entities the executive order does not apply to, and that's on the next slide, or this is the slide that we're on here. So it doesn't apply to existing contracts or contract-like instruments, at least unless and until they're renewed or extended. So in other words, the requirement is not retroactive. However, as we'll discuss, once the contract clause becomes effective as to a particular contract, covered contractors will be required to comply with any changes that are published. We'll talk about what that means a little later as well. The executive order also does not apply to contracts with Indian tribes. It doesn't apply to employees outside of the United States or to subcontracts solely for products. Nor does it apply to federal grants or contracts or subcontracts whose value is equal to or less than the FAR simplified acquisition threshold, which currently is $250,000. That's set out in the FAR. So I think it's becoming apparent that the executive order itself is not long on detail. Rather, the White House and President Biden left the specifics to be spelled out by the Safer Federal Workforce Task Force, directing the task force to publish guidance by September 24th, 2021. I'm sure many folks, myself included, were fairly skeptical of the task force's ability to meet that September 24th deadline, but we were all proven wrong. The task force did issue detailed guidance on September 24th that, as required by the executive order, was approved by the director of the Office of Management and Budget and published as effective on September 24th.
Yeah, an interesting thing about not applying to Indian tribes, for the contractors out there who may be dealing with Indian tribes, casinos, et cetera. These are Indian tribes are considered sovereign nations. They're subject to their own set of procurement laws, and a contractor's got to be very careful when in contracting with these sovereign nations. I mean, for example, on one particular tribe that we're involved with, I mean, in order for the contract to be valid, it has to be signed not only by the tribal chief, but also the head of the Bureau of Indian Affairs and the Department and the Secretary of the Interior. And wow. If it isn't, it's subject to disgorgements. In other words, so there are very, very, very dangerous provisions within those. So you really need to be very careful when you're. So it doesn't surprise me that that Indian tribes were exempted from this particular protocol.
Right. Okay, let's move to the next slide. So before I dive into what's in the new guidance, I thought I'd spend just a moment explaining what the Safer Federal Workforce Task Force is, how it came about, and so forth. So the task force actually was established by President Biden in one of his first executive actions after becoming president. So on Inauguration Day, President Biden, as you know, signed a number of executive orders, including Executive Order 13991, which, as folks may recall, mandated masking for all federal employees and on-site contractors. The executive order also created the task force, which is composed of federal agency heads from across government, including OMB, the Office of Personnel Management, which is essentially the HR department for the federal government, as well as the directors of the Secret Service and the CDC, among others. Next slide. So these government officials and agency heads came together and, again, as required by the executive order, issued a detailed guidance document that is designed to implement and enforce the executive order. There are three main components to the guidance. There's the vaccination mandate, there's the requirement to wear a mask and to follow the CDC's physical distancing guidance, and the requirement that covered entities formally create, to the extent that they haven't already, a formal committee or group that is tasked within the organization with coordinating workplace COVID safety requirements. By the way, the guidance very helpfully contains a series of FAQs, frequently asked questions and answers, which, by the way, have been updated even since September 24th, and presumably will continue to be updated as new or different issues arise. So just so that everyone understands, the guidelines require covered contractors to mandate vaccinations. They cannot simply implement masking and distancing requirements. So vaccinations and masking and distancing are required for all contractor locations and employees. It's not an either or, as was initially suggested in the White House fact sheet earlier this summer, right, that we just discussed a few minutes ago. So while the guidance does not say so explicitly, the implication clearly is that workers who are not otherwise exempt may be discharged for refusing to get vaccinated, even if they work remotely, by the way. So that is a good segue into how the guidance defines, again, the important terms, Joe, that you were teeing up early, like contract, contractor, contractor employee, and that sort of thing. Let's turn to the next slide. So key definitions. The executive order applies to covered contracts or contract-like instruments, the definition of which is derived from, interestingly, a definition that is contained in the DOL, the Labor Department's proposed rule to implement the $15 federal contractor minimum wage executive order that President Biden signed earlier this year. As you can see here, the term is defined again extremely broadly. The actual guidance language specifies that, I'm going to read it verbatim. It says, the term contract includes all contracts and any subcontracts of any tier thereunder. There's your question answered, Joe. Whether negotiated or advertised, including any procurement actions, lease agreements, cooperative agreements, provider agreements, intergovernmental service agreements, licenses, permits, or any other type of agreement, regardless of nomenclature type or particular form, and whether entered into verbally or in writing. The term, it goes on, the term contract shall be interpreted broadly, no kidding, as to include, but not be limited to, any contract within the definition provided in the FAR or applicable federal statutes. This definition includes, but is not limited to, any contract that may be covered under any federal procurement statute. So
there's going to be some interesting cases making their way up to the federal courts, to the U.S. Claims Court and the Board of Contract Appeals, alleging breach of my contract-like instrument, okay, and citing this particular executive order. So it's
right. Well, and the definition of contractor workplace location also is, I might say, intentionally broad, and defined as a location at which a covered employee works, including the contractor's workplace or a federal work site. So you may ask, does workplace location include, in the case of remote workers, a private residence? Well, that's a good question. Confusingly, the term contractor workplace location doesn't mean the same thing as a covered contractor workplace. Let's go to the next slide. So to answer that question, a covered contractor workplace is a location controlled by the contractor and excludes the covered contractor employee's home. But any employee working at a covered location, regardless of whether the individual is working on or in connection with a federal contract, is covered and subject to the executive order. So you see what they did here? These definitions reinforce each other and also continue to reinforce the intentionally broad scope of the executive order. So what the carve out as to the employee's residence means as a practical matter is not that a covered employee working from home is exempted. In fact, the FAQs state explicitly that an individual working on a covered contract, or in connection with, remember, a covered contract from home, is a covered contract employee subject to the vaccination requirement, even if that person never steps foot in a physical workplace location or federal government site. So I think the residence carve out, I think, is meant to confirm intuitively and obviously that a covered contractor employee doesn't have to implement the vaccination, masking, and distancing requirements with respect to activities at their home. But that's really the extent of it. The FAQs are very clear that employees working on or in connection with a government contract who are working remotely are covered and subject to the executive order, even if their home is not considered a work site, if you will.
And the employer has the obligation to question that employee working at home to confirm that that person is properly vaccinated. And if, in fact, the person is not properly vaccinated, they have the ability to, or the duty to let that person go?
Yes, sir, in a nutshell.
Mm-hmm.
But we'll suss it out a little bit more. Next slide.
Mm-hmm.
So again, just to summarize, the vaccination mandate applies to all workers, whether full-time or part-time, who work on or in connection with a covered federal contract. The FAQs make clear that the phrase "in connection with" also is to be construed broadly, and it actually says specifically, it provides examples that demonstrate that it extends also to administrative, operational, and some back office functions to the extent that they're necessary to the contractor's ability to perform on the contract, such as, and these are examples contained in the FAQ itself, HR operations, billing and payroll, and legal review. Those are three of the specific functions that are called out in the FAQ for purposes of providing an example.
Yeah, and there are many, RFPs that are issued these days, seeking for legal services to do X, Y, and Z, advice on EPA grants, or advice on design build agreements, et cetera. So I presume that if you've got a direct contract, if you're a law firm, you got a direct contract with the federal government, okay, and an executive agency to advise them that you're covered by the mandate.
Very possibly so. I will say that obviously Joan nor I is authorized to render legal advice. Obviously, we're appearing here in our capacity as consultancy leaders, but on specific questions about contract coverage, contractors or would-be contractors are wise to confer with their legal counsel just to make sure that they have a good understanding as to whether or not they are subject to the executive order. So the guideline establishes a deadline of December 8th, 2021. That's just about 2 months from today for all covered contractor employees who are not otherwise exempt to be fully vaccinated. So really anyone who has not received their first shot has to do so as a practical matter by the end of October or so in order to meet that fully vaccinated deadline. Next slide. So, and this is going to the question that you teed up, Joe. Contractors not only must mandate the vaccinations, but they also have to verify employee compliance by requiring that they provide proof of vaccination. Now, not all proof of vaccination is the same. Not all are created equal. And the forms of acceptable proof are specified in the guidelines themselves. And they include a record of immunization from a healthcare provider or pharmacy, a COVID card, a COVID vaccination record card, medical records documenting the vaccination, immunization records from a public health or state immunization information system, so one of the online tracking systems, or any other official documentation verifying vaccination that shows the name of the vaccine that was administered, the date that it was administered, and then the administering provider, healthcare provider.
Is there a confidentiality issue here that floats around that people say, well, I'm going to give you some certain information, but what happens is you got to keep it confidential? Is that a consideration?
Absolutely. These are certainly confidential records and they must be treated as such. Another question that comes up is with respect to what form of proof is acceptable. An attestation of vaccination status is insufficient. The FAQs make that clear, that an attestation of vaccination status will not satisfy the contractor's obligation, nor may a contractor accept a recent antibody test in the place of a verifiable and official proof of vaccination. So I think that's important clarification for people to keep in mind as they begin to build up their processes and systems for ensuring compliance with this vaccination mandate. There are a couple of questions that have come in. One pertains to the December 8th deadline. And the question is, there's a December 8th deadline, but doesn't the clause need to be incorporated into a covered contract before a federal contractor is obligated to comply? Yes. And we're going to talk about when the clauses will become effective in a moment. And by the way, I will say that, well, we'll get to it in a moment. We'll talk about that in just a moment. Let's move on to the next slide. So in addition to the vaccination requirements, which clearly may be the most controversial, contractors also under the executive order must follow and make sure that their employees are complying with the CDC's guidance on masking and physical distancing. This includes making sure that all workers wear masks and practice physical distancing, even inside, if they're located in areas of high or substantial community COVID transmission. What this is going to require as a practical matter is that contractors will have to keep track of community transmission information, which is updated and made available on the CDC's website. There are some exceptions, acceptable exceptions to masking, including while a worker is eating or drinking, or where the employee, for instance, is the only occupant in a closed office, as well as in limited safety risk situations as determined and also per the guidance approved in writing by the COVID team that the employer has set up. Now, to the extent that there are workers who are exempt from the vaccination requirement, maybe as a disability or a religious accommodation, they still must remain masked and practice physical distancing generally at all times, regardless of the level of transmission in their particular community. So even in areas of low transmission, the expectation and the requirement for unvaccinated workers is that they remain masked at all times and practice physical distancing. I should note as well that there may be instances, by the way, in which an individual with a disability requests an accommodation to the masking requirement. I would just say that that type of requirement, that type of request should be handled in the normal course as you would handle any request for a workplace reasonable accommodation under the ADA.
Yeah, my understanding is that for religion, they have to have a sincerely held religious belief. That's my understanding there of the set the standard for, yeah, and that
yes.
and that the accommodations that are being made have to be reasonable and without I take it without due burden on the other employees. You could say, well,
right.
I've done something reasonable, but it's going to affect and potentially harm other people. So that wouldn't be a reasonable accommodation.
Yes, and Joe, we could spend another 3 hours talking about workplace reasonable accommodations under Title VII, which is the religious accommodation piece, as well as under the ADA. But you are absolutely right. With respect to a request for a religious accommodation, it has to be based on a sincerely held religious belief of the employee that conflicts with a work rule or requirement, right? And further to your point, the employer is obligated to consider reasonable accommodations up to the point of undue hardship. And we're probably most familiar with the concept of undue hardship in the ADA context. In the Title VII context, the standard is significantly less onerous on employers. So if a proposed accommodation would impose more than a de minimis hardship on business operations, the employer is not obligated to provide the accommodation. But yes, so to your point, that's a very important piece of information for folks to be aware of. But I don't want to get us too far sidetracked at this point. So let's go to the next slide. So as we mentioned at the outset, one of the core requirements of the executive order is that contractors establish and assign COVID guidance safety coordinators. These folks are going to be the points of contact for ensuring compliance with the guidance. The guidance says that these people can be the same folks who are already in place to the extent that many organizations and businesses are already subject to rules regarding, mandating or monitoring compliance with other workplace safety rules. Importantly, this team of folks is responsible for communicating protocols, masking, physical distancing, and things like that, both to employees as well as visitors. This should be done through written communications, policy statements, signage, posters, and things like that. But perhaps most importantly, according to the guidance, this group is ultimately responsible for ensuring compliance with the proof of vaccination requirements. So it's important to, and we'll discuss when we talk about some best practices, to make sure that you have aligned and set up your committee or group or task force or SWAT team with the tools and information that it will need in order to ensure compliance. And I will say also that with respect to resources, the CDC has an entire section on its website that's devoted to general COVID resources and downloadable posters and toolkits and things that may be helpful to companies that are needing to start from scratch in building up this type of committee or group. Next slide. So breaking news, remember I referenced earlier, there was a bit of breaking news just a few days ago. On Friday of last week, the Federal Acquisition Regulation Council, the FAR Council, published an agency deviations memo providing guidance on how federal agencies are going to be expected to implement the executive order pending formal amendment to the FAR. So the publication of the deviations memo, by the way, coincides with the start of the new fiscal year 22, when probably many government contracts may have been renewed or extended. By the way, a deviation under FAR simply means that an agency is utilizing a solicitation or a contract clause that hasn't been authorized by the FAR or has not yet been incorporated into the FAR or the agency acquisition regulations. So what the deviation memo does is provide cover and authority, if you will, for agencies to implement or include the contract clause text into contracts as soon as October 15th, while we're awaiting the formal FAR regulation amendment. So the relevant substantive provisions of the contract clause language text that was included in the FAR memo is on the next slide. Let's move to the next slide. So this language is really important. With respect to compliance, the contract clause provides that the contractor shall comply with all guidance, including guidance conveyed through frequently asked questions as amended during the performance of this contract for contractor or subcontractor workplace locations published by the Safer Federal Workforce Task Force. And the website is there. And then it specifies the obligations, the flow down obligations that apply to subcontractors. So as you can see-
At any tier.
Yes, at any tier, at any tier, right. As you see here, you know, it's interesting, the clause provides flexibility on the government side in the language of the clause. So it says, well, you know, we're gonna amend and update and revise as we see fit. It's your responsibility, contractor and subcontractor, to ensure that you keep abreast of any and all applicable changes to the guidance that impact your compliance obligations under the executive order. So very interesting, again, how that language reads. Next slide. So this goes to one of the questions that we saw. So what are the effective dates? On or after October 15th, that's the trigger for current contract options or extensions. So what the guidance says, in addition, is that as of October 15th or beginning on October 15th, contracting agencies will begin including the contract clause in all contract solicitations that are made or published between October 15th and November 14th. As of October 14th, the clause is going to be included in all new contracts. So all new contracts awarded on or after October 14th, or I should say after October 14th, will have to have the contract clause incorporated. Now, prime contractors also, under the guidance, are obligated to verify that the flow down clause has been incorporated in their first year contracts, and then subcontractors carry that obligation with respect to their subs, second, third tier subs, and so forth. So an updated FAQ was added after September 24th that clarified that prime contractors don't have to police their subcontractors' compliance affirmatively and can basically take the subcontractors at their word unless the prime contractor has information suggesting that the subcontractor is out of compliance with the executive order. Next slide. Oh, fun. So let's now talk about the ETS. Before we do, though, are there any questions yet on that yet still remain with respect to the executive order?
There's a question here that said, the problem with testing is that results are not received within the required parameters. How are we supposed to comply with testing employees that refuse vaccination if results are not back in time and testing sites are refusing to test, or employees just to test even though it's mandated?
Very good question and comment. It's an issue. You know, it's one of a number of practical issues that contractors are going to be facing in ramping up for compliance under the executive order. There may be some opportunities for contractors to change their approach. You know, one of the other questions, which we're going to talk about later, is related. Who pays? Who pays for all this testing? Testing can be expensive. And I will sort of preview what we'll discuss in a few moments with respect to the ETS. The expectation is that the ETS may well place the burden on employers, but the whole situation is fraught, at least at this point in time. The good news is that it appears that the task force continues to update its guidance to address practical issues that are coming to its attention through, you know, stakeholder communications and things like that.
Yeah, and there's already been some pushback on this entire guidance. You know, there's lawsuit was that involved federal workers fire, Air Force officers, Secret Service are pushing back, unions are pushing back. I mean, some quote religions are selling religious objection certificates, etc. You know, it's going to be a little bit rocky, I would suspect. And Engineering News Record, for example, it says they are soliciting a survey on the mandates, as a matter of fact, of contractors. So it's going to be a lot of to be continued stuff with probably the subject of our next podcast, right? Coming up.
That's right.
Coming up soon. But
That's
anyhow,
right.
I interrupted you as you're moving on to OSHA.
Yeah, so the OSHA ETS, again, was mandated on September 9th by President Biden. It's expected to be released, quote unquote, in the coming weeks, and that time frame has been repeated by the White House and other government officials repeatedly. So no, there is no more specific time frame within which we should expect to see the ETS, although I will say that some employer stakeholder groups have been in discussions with DOL on a number of practical issues, and the sense I get from those groups is that DOL is looking to publish something by the end of October. By the way, they will do so without putting the rule out for notice and comment rulemaking. So there won't be an opportunity for stakeholders to actually comment on and propose changes to the ETS before it's actually published. As we said at the outset, it's going to apply to all employers with 100 or more employees, and covered employers will have to ensure that workers are either vaccinated or get tested weekly, okay? It also is expected to require employers to provide paid time off for employees to get vaccinated or to recover if under the weather post-vaccination. And at least as far as we understand to this point, will provide for substantial monetary penalties for violations up to a maximum of $13,800, almost $14,000 per violation, not per workplace or employer, per violation. Also made very clear in the guidance and other information that's come out of the White House and the task force is that contractors who are covered by the guidance as well as the ETS, so larger contractors with more than 100 employees, are going to have to comply with both rules. So the ETS, as we understand, will apply to all full-time, part-time, and temporary employees. Only independent contractors, as we understand it, will be excluded. We're not sure how much lead time employers are going to have to comply after the ETS is issued. You might recall that with respect to the healthcare ETS that was issued back in June, covered employers had between 15 and 30 days to comply. We just don't know what the situation will be with respect to this COVID, this broader, more broadly applicable COVID ETS. The employer groups that I mentioned before have asked DOL to provide at least 90 days lead time, but again, it's unclear if DOL will do so. Also should mention that the ETS will be in place until a permanent regulation is issued. Now, what's really fascinating and has given rise to, I guess, more controversy surrounding this ETS, this expected ETS, is the fact that over the course of OSHA's history, it's only issued 10 ETSs, including the healthcare ETS that was just issued back in June. And prior to that, I believe that the last ETS that was issued came out in the early 1980s during the Reagan administration. So, you know, when people talk about this effort as being quite extraordinary, it's not hyperbole. It really is quite extraordinary.
Okay, your last two slides are on some practical considerations, and we got some questions too in the queue, but maybe you can move on to the practical considerations that you wanted to share with people.
Yes. So as a threshold matter, it's important to acknowledge the potential employee relations issues that invariably are going to come up once contractors start enforcing the vaccination mandate. There still are individuals who are unvaccinated and for a variety of reasons are hesitant to get vaccinated. So as we've seen with some of the large corporations that you mentioned earlier, Joe, as well, that have imposed company-wide mandates, invariably there are going to be workers who threaten to quit or threaten to sue. Also, as a practical matter, how far will contractors have to go, if at all, to make on-site testing or vaccinations available? So going to the question that was asked before, the executive order and the guidance are pretty clear that while those types of efforts are encouraged and welcome, they're not required. And I assume, although again, we don't know, I assume that the OSHA ETS will follow suit, but we just have to wait to see what's published. But to get back to the practical question, if you have a not insignificant portion of the workplace that's unvaccinated, again, going to the question that was asked, how do you manage getting the testing done quickly and efficiently? Another issue that is related, that is worth mentioning at this point in time, is that there are potential wage and hour implications and issues to the extent that the DOL has said that COVID testing is compensable. meaning that non-exempt employees are entitled to be paid for time spent complying with the employer mandated or imposed testing requirement. And then there's the still unresolved issue of who pays, again, for the tests. Now, this is an interesting approach that I'm going to suggest here. Depending on how large an employer's population of unvaccinated workers is, an employer that isn't already subject to the executive order, so say one that's looking at compliance under the ETS, may, if it hasn't already done so voluntarily, it may consider not making the testing option available as a general matter, except of course in the case of reasonable accommodations, and mandating vaccinations, since vaccines are free and widely available. So, that is one possible answer to the who pays for COVID testing and how do we possibly manage all of those costs. On the mitigation question, I'm a huge believer in communicating regularly, often with your employees. So communicating often to your employees about what the guidance requires, updates in the guidance is a good start, in addition to obviously making sure that those, again, who are responsible for implementing the requirements are well trained and understand the rules. I would be interested in hearing, though, from participants about some of the approaches that they're thinking about taking or maybe have already implemented. Joe, do you have any thoughts on that?
No, I really don't. I really don't. It's I'm in your wheelhouse on these particular practical considerations.
So one question that's come in is, it's a good question, who is liable, the GC or the sub, when the subcontractor employees are working on job conditions that don't meet the mandate? So very interesting. We don't know. The executive order does not contain a section on enforcement. And so really the question is whether the FAR enforcement mechanism would apply here. Presumably it would. So the FAR empowers contracting agencies to pursue debarment of a contractor for failing to comply with contract conditions in a manner that, is substantially problematic.
Yeah, and I think from a contract point of view, the GC is going to flow down the obligations to the subcontractor, probably with an indemnification, saying you violate these things, and as a result of it, I get hammered in some way, then you're responsible for those damages. And so, and who knows, maybe it's good, maybe that'll be insurable too.
Right. Let's flip to the next slide. So just some high-level tips and strategies that we have for you in thinking about how to begin to wrap your arms around your compliance obligations under the executive order, and also starting to prepare for the ETS. Go back and look at what your existing COVID safety procedures are. Do you have a COVID SWAT team in place? Who makes up that team? So with respect to the federal employer or employee workplace, the guidance applicable to that group outlines, gives some tips or suggestions as to the people who should be part of that team. HR, obviously, occupational health and safety, legal, a member of the executive management team. So those are the types of folks and functions who you'd likely want to have represented on this type of team or group of folks. Again, making sure that they understand specifically what the guidance requires and how the guidance and the executive order applies to you will be important in carrying out these additional compliance obligations and providing updated notices and information and so forth. And then perhaps most importantly, this team needs to get together and develop or at least refine any existing vaccination and COVID testing protocols to ensure compliance with the guidance specifications, especially with respect to the type of proof that is permissible and how to store those records, and then, of course, being in a position to respond effectively to any religious or disability accommodation requests.
Mm-hmm. We're at the end of the hour, but there are a couple of unanswered questions. So I wondered, Ray, if you could just take a look at those and see if we can knock off a few before we close.
So, sure. One question here is, so if you don't have a contract renewal pending, you don't have to comply until the contract clause is incorporated? Correct. Although I will say that I read something in the guidance, I believe, that, or it may have actually been in the FAR memo, that suggested that this language could be incorporated by reference. But again, the point in time for incorporating the contract clause would be upon renewal. So it's possible that some contracts won't have the clause included until 2022.
And then is a contractor entitled to an additive change order for the cost of compliance with the guidance? I suspect not. Okay, I suspect not. But it's an intriguing question for existing contracts. All of a sudden, the guidance comes down on it because there's change in the law sections in FAR, and so there may be a window there, or if it creates some sort of disruption to the job in some way, okay, there may be a loss of efficiency claim. So, but from a legal point of view, it's going to be a very interesting question to wrestle with. And Jim Simpson asks, what's the relevance for the exclusion for contracts less than $250,000?
Well, I suspect it's not really explained, but I suspect that it's an attempt not to overburden relatively small contractors. So contractors with contracts valued at less than $250,000 are probably smaller contractors for purposes of these compliance obligations. So I suspect, although I don't know for sure, and the guidance doesn't really explain why smaller contractors would otherwise be excluded, but I suspect that's the reason, just not to overburden smaller contractors.
And I think the last question here, are you aware of any mandate requirements for contractors who don't work on federal projects? And I think from my perspective, you handle that beautifully in the podcast that we did, explaining the various labor and employment regulations that go to federal contractors and non-federal contractors. And, I don't know if anything else you want to add to.
I would just say that for non-federal government contractors who have at least 100 employees, you're going to have to ramp up for application of the ETS, because that will probably apply to you. And then I would also be remiss if I did not mention the fact that there are, again, or reiterate the fact that there are some states and localities that do impose stricter requirements than we see here. So you should always work with local counsel to ensure that you are up to speed and conversant in whatever local or state requirements apply. And with that, I think we're at the end.
We're at the end, and I want to thank you so much, Ray. It's great. There's a lot of meat in this particular guidance. I use that word advisedly, guidance that we've gotten from the government. And I guess I'll promise our listeners for a new podcast as we sort of get the effect of the pushback and the questions that are going to be asked publicly. And for our listeners out there, I mean, if you have any questions of Ray or me, from a legal point of view, shoot them to R. Vann at Carlton Fields, or Jay McManus at Carlton Fields. And if you need some help on a consultant side to help you with putting together a program or whatever, then reach out to Ray or myself. Okay, so we can give you a hand. But hopefully we'll look for you in a podcast in a couple of weeks and see where all this gets us. Thanks again for everybody for showing up. Thank you, Ray.
Thank you.
Bye-bye.